Everyone still seems to think that foreign companies and foreign trusts are like this massive loophole and you can just do whatever you want if you're rich enough to have one. They're almost always a very bad tax idea to do because in the 90s people were doing this and they threw in those laws that stopped it happening. And it's not like these things are expensive. You can get like an offshore tropical company for about $3,000 to $5,000 US, even cheaper if you know where to look. So government made the CFC rules, the controlled foreign company rules, to basically stop people accumulating passive investment assets in foreign companies. No matter how many layers deep you put it, if it's ultimately owned and controlled by an Australian, the CFC rules will generally come back and bite you. For foreign trusts, there's the transfer of trust rule, and those rules are even harsher than the CFC rule. If you're an Australian tax resident, you don't want a foreign trust anywhere near you. I've dealt with foreign families and one kid comes to Australia, we have to say to them, you have to cut them off from the trust while they are an Australian tax resident. They cannot benefit, they cannot control anything. Pretend it doesn't exist. Like, if you really want one, we can set you up with one, but we're not going to be able to give you tax advice that it's a good idea. And if your only shield is privacy, it's a very, very weak tax structure and it will eventually blow up in your face. We saw this from the Panama Papers, Pandora Papers, Paradise Papers. There'll be another one. These data leaks will happen again. And if your only defense is, I didn't think anybody would know, I have a nominee director, a nominee shareholder, it's not really going to cut the mustard with the ATO. There are some scenarios where it's not a bad idea. In fact, it's necessary and can be good tax planning, but that'll be for another video.